A federal district court just delivered a big home run for people who want answers to a lot of questions that came out during the pandemic. Fauci and Psaki ordered to be deposed by a federal court. We're going to take a look at this. Remember the two people we're talking about. They're just two in a long list of other people who have been ordered to also be deposed, to sit and answer questions based on a lawsuit brought by the states. And it is a lot of fun. I've got a lot of questions for them that I'd like to see answered. We'll see what comes out in the deposition. But let's take a look at the document that was filed here. And you can see it's semi-big. The state of Missouri versus Joe Biden. Judge ordering the depositions of Psaki and Fauci. 28-page order drafted by Judge Terry A. Doherty. A memorandum order regarding witness depositions. So it's an order with a memo. Oftentimes on this channel, we see orders and they're just a one-page order or 2 pages. Very small, very short. Do this thing and do this thing. That's it, signed off on by the judge. In this case, the judge is drafting a memorandum order, meaning there's going to be a big explanation for why these depositions should take place. The judge writes, this court granted prior motions for expedited preliminary injunction-related discovery, saying that I granted the state, which in this case is the state of Missouri, suing Joe Biden, alleging that there was collusion between the big tech companies and people in the Biden administration. They're suing. Missouri said, we want answers on this collusion. We know that you were putting the pressure on Facebook and others during the pandemic, and we got questions for you. So the judge granted expedited discovery, saying that both of these sides can get access to materials. The discovery schedule required the parties to meet about any deposition requests. The parties were to file a joint statement as to their positions, and the parties have done so. The judge is saying this is the ruling on the witness depositions. The states want depositions from tons of people. Remember, all of these people were named in the lawsuit. Joe Biden, Vivek Murthy, Xavier Becerra, Department of Health and Human Services, Anthony Fauci, NIAID, CDC, we got Alejandro Mayorkas, Jen Easterly, Cybersecurity, Nina Janke Jankowicz, Karine Jean-Pierre, Jennifer Shopkorn, Robert Silvers, and others. Okay, a whole list of people. The states that are suing are Missouri and Louisiana. Shout out to our friends in both of those incredible states. They're suing, and the court gives us some background. The court says, on May 5th, states sued Biden. In the complaint and the amended complaint, the states allege that the Biden administration has colluded or coerced social media companies to suppress disfavored speakers, viewpoints, and content on social media platforms. They labeled all this stuff disinformation and misinformation and malinformation, right? These 3 new categories of speech that really didn't exist until the pandemic hit. Now we all have to be extra cognizant about what we say, lest we fall into one of these fake categories. The states allege that the suppression of these disfavored speakers, these viewpoints, and these contents of these conversations constitutes government action, meaning the government was acting on these private tech companies. And that, because they were doing that, it violates the state's freedom of speech and the First Amendment. In the lawsuit, they set forth several examples of the suppression of free speech. One of them includes the Hunter Biden laptop story prior to the 2020 presidential election, which we covered here, which was absolutely suppressed everywhere. Number 2, another issue, speech about the lab leak theory and COVID-19's origin, another thing that we were suppressed on and actually got a strike for misinformation on. Speech about the efficiency of masks and COVID-19 lockdowns. Speech about election integrity and the security of voting by mail, censorship and the suppression of different plaintiffs and people at the Gateway Pundit and others, and censorship of a co-director of Health Freedom Louisiana on various social media platforms. The states move for the following government officials to be deposed. Here's the list. Look at this juicy meatball right here laid out deliciously for us. Everybody's on this list. We got a lot of questions for all of them. Psaki, White House Digital Strategy, Rob Flaherty's on there. Andrew Slavitt, COVID-19 advisory, Jen Psaki, FBI agent Elvis Chan, CISA director Jen Easterly, Surgeon General Vivek Murthy, and others, all sitting for depositions. Now, that's what the states want. Missouri, Louisiana, they say, we definitely want to hear from Psaki and Fauci, so get them ready. Now, the defendants, the government, the Bidens, of course, they opposed the depositions of everybody. They say, nah, we definitely don't want to do that. Now, they give us some law, and they are going through the different rules for when we can do depositions and not. And so we're going to see how the court applies all of the rules here in a minute. So we'll fast forward through some of this. But they say that the government, the Biden people, they've objected to the state's requests for depositions. They say, well, first of all, you didn't name them in the original complaint, and so they're outside the scope. They're like, well, you didn't sue them originally. Karine Jean-Pierre was not in the original lawsuit, and so you can't cite her. And they say also that the states have not demonstrated exceptional circumstances to depose high-ranking officials. High-ranking officials get extra protections. They're high-ranking after all. And we have to make sure that they're protected against very inconvenient depositions from the lowly states. And the government says they haven't met that burden. Each proposed deponent must do so on and so forth, and you can see they're analyzing the factors. Now, the states say that the officials are needed for the reasons that follow. The states start with Fauci. Dr. Anthony Fauci, the NIAID director and the White House chief medical advisor for the Bidens. Missouri and Louisiana, they want him, and they want him bad. They say Dr. Anthony Fauci, who is a named defendant in this case, is the director for all sorts of medical operations. And we move to depose him for substantial reasons. First, the states claim, this is the judge writing, the states claim that Dr. Fauci is directly involved with multiple social media censorship campaigns against COVID-19 misinformation. The states argue that, quote, speech backed by great scientific credibility and with enormous potential nationwide impact has contradicted Dr. Fauci's views. It has been censored because of the insistence of Dr. Fauci. Fauci says this is how the science goes. Everybody else says no. Guess what happens on social media? Everything that is not in alignment with Fauci, it's suppressed. It's gone. The states have some examples. They say the first one is Dr. Fauci's efforts to discredit any theory that COVID-19 was the result of a lab leak. The states say that Fauci, quote, had funded a risky gain-of-function research at Wuhan. And all of that was led by Peter Daszak. In turn, that meant that if there were truth behind the theory, that Dr. Fauci and Dr. Daszak were colluding in this story. And we covered this at length during our pandemic extravaganza. I mean, back when this channel was just starting in 2020, we talked about the pandemic basically nonstop. We talked about Fauci, Daszak, EcoHealth Alliance, the entire litany. And shortly thereafter, it was all suppressed. It continues. In late January and early February 2020, information on the lab leak theory began to spread to the public. And we got our first warning. Our first strike on this channel was a warning for medical misinformation right around this time. Soon thereafter, Dr. Fauci participated in a conference call with scientists and science funding authorities, which may or may not have been about discrediting the lab leak theory. We even looked at the emails for this. The states assert that after the conference call, influential individuals signed public statements that were placed in science journals in an attempt to discredit the lab leak theory. We read through all of these. During this time, states also urged that Dr. Fauci engaged in written and oral communications with Mark Zuckerberg about the government's COVID response, and allegedly widespread social media censorship of the lab leak hypothesis ensued. They say states further this argument against Dr. Fauci by pointing out that the publicly available emails between Dr. Fauci and Dr. Collins regarding their efforts to discredit the lab leak theory, which states assert led to the censorship of the theory online. They say that these emails from Fauci and Collins were both aware of certain scientists' concerns that the COVID virus was bioengineered, they said. However, those same scientists authored a paper for Nature Medicine that discredited the lab leak theory just days earlier. And they advocated that to Fauci. That paper was sent to Fauci for approval. The states allege that Fauci and Mark Zuckerberg commenced a course of friendly oral communications about the government and their response. The states wish to ascertain the contents of these communications in depositions. What was Mark and Dr. Fauci talking about? On April 16, 2020, Collins emailed Fauci a link to a Brett Baer article on Fox about the lab leak theory. Collins expressed concerns over whether the NIH can help to take down the very destructive conspiracy. That seems to be growing in momentum, and we read through all of that here. He further stated that he hoped the Nature Medicine article would settle this. And Dr. Fauci cited that article while speaking from a podium at the White House. Fauci and Collins also communicated about the Great Barrington Declaration, which was a scientific critique of the effects of a prolonged lockdown as a response to something authored by several other doctors. There were emails back and forth. Dr. Collins sent one over to Fauci and said, "Hey, Tony, this proposal from these 3 fringe epidemiologists who met with the secretary seemed to be getting attention. Can you deal with this?" Fauci began making a series of public statements that were highly critical of the declaration, calling it total nonsense and ridiculous. And there was a senior Health and Human Services official called for a quick and devastating takedown. Now, they say that Fauci was also involved in Twitter's permanent suspension of Alex Berenson. Remember him? He was a very big sort of anti-COVID thought leader, really, during the time. Fauci got rid of him. Berenson's tweets consisted of science-based objections to young people. The states say that Berenson disclosed internal Twitter communications revealing that a senior White House official, including Andrew Slavitt specifically, pressured Twitter to deplatform Berenson. The White House pressured Twitter to deplatform somebody. Twitter did. Fauci publicly described Berenson's opinions on the vaccine as horrifying. Biden followed Fauci's steps and made a statement that they're killing people by not censoring this information. Twitter subsequently permanently banned and suspended Berenson. Berenson posted different Twitter emails indicating that a board member from Pfizer pressured Twitter to deplatform Berenson. In the emails, Pfizer executive allegedly claimed that Berenson's speech should be censored because it posed a threat to the safety of Fauci. It's all about that. So got to cancel Berenson because Fauci might get injured. Yeah. The states argue that this creates an inference that there was collusion between Slavitt and Pfizer and others. Now, the government says that no, they say that Fauci has no direct communications with social media companies. The states say that, well, we shouldn't be required to accept that. Okay. The government says Fauci, we've got all these different liaisons. Fauci should be immunized because he doesn't directly conversate with these big tech platforms. But the states say, well, we're not simply accepting those blanket statements as they're submitted. And they argue 3 reasons why Fauci should be questioned under oath. We're not taking your word for it. The states say, first, Dr. Fauci has already refused to verify under oath his own interrogatory responses. Interrogatories are a list of questions that you send to either side to sort of save time. You send tell me all this crap and you fill it out. Fauci apparently has filled one out, but he's not filing it out under oath. They say that the NIAID's responses were instead verified by Dr. Jill Harper, who was not named in the complaint. We don't want Jill's affirmations. We don't care. We want yours, Anthony. Accordingly, Dr. Fauci has made no statements under oath regarding his communications with big tech, and that violates this court's orders. They say next, the states say that even if Dr. Fauci can prove that he never communicated with big tech, there are compelling reasons to suggest that Fauci has acted through intermediaries or acted on behalf of others in procuring the censorship of credible scientific opinions. The states argue that even if Dr. Fauci acted indirectly or as an intermediary, it's still relevant to the states and to their motion. And the court agrees. And finally, Plaintiffs argued that Fauci's credibility has been in question on matters related to misinformation since 2020. States say that Dr. Fauci has made public statements on the efficacy of masks, the percentage of the population needed for herd immunity, the NIAID's funding of gain-of-function research, the lab leak theory, and more. The states say that his comments on these issues are relevant to the matter at hand and further reasons why Dr. Fauci should be deposed. The states say that they should not be simply required to accept Fauci's self-serving blanket denials that were issued from someone other than him at face value. And the court says, we agree with that. So the court concludes here. They say, after reviewing the states and the Biden administration's arguments, the court finds that the states have proven that Dr. Fauci has personal knowledge about the issue concerning censorship across social media as it relates to the pandemic. The court has considered that Dr. Fauci is a high-ranking official. We know that, especially as he's the director of the NIAID and he's the chief medical advisor to the president. The court sees only the potential burden imposed upon Fauci as a result of him being deposed is that of his time. That's really the only downside. If he has to be deposed, it's time. However, the court acknowledges that any person who is being deposed must sacrifice their time. And it does not see any burden imposed on Fauci that outweighs the court's need for the information in order to make an informed decision. So the court is sort of saying, I know it's a pain. A deposition is a pain, and he is a high-ranking official, but we really do need this information. And the states have proven that he's kind of in the center. He's kind of the nexus of a lot of these issues. So we're going to allow the depositions forward. Finally, the court writes, the court is aware of a number of substantive reasons why Fauci's deposition should be taken. The first is that the publicly available emails that prove that Fauci was communicating and acting as an intermediary for others in order to censor information from being shared. Judge says, I've seen those emails too. Yeah, I've seen them. The second is that Fauci has yet to give any statements under oath in this matter. No, he deferred that over to his underling. And the third is that the court has no doubt that Dr. Fauci was engaging in communications with high-ranking social media officials. And that is extremely relevant at hand. Additionally, the crux of this case is the fundamental right of free speech. Preach, Judge! Any burden that may be imposed on Dr. Fauci is wholly outweighed by the importance of the state's allegations of suppression of free speech. Accordingly, the court finds that the states have satisfied their burden of proving why a deposition of Dr. Anthony Fauci is necessary in this case, and exceptional circumstances are present. Accordingly, it is ordered that Dr. Anthony Fauci cooperate in the state's request to depose him for purposes of their preliminary injunction and discovery. Deposed. Now you can see they go through a very similar analysis. Rob Flaherty is obviously somebody who had extensive oral meetings on Twitter, Meta, and YouTube. Plaintiffs say that he consistently communicated with U.S. public policy leaders through COVID insight reports. He sent it over to Meta. Meta allegedly contacts Flaherty when there's new issues that pop up. Okay, they are communicating back and forth. Flaherty had specific knowledge about Meta's attempts to censor the disinformation dozen. Footnote down here. Supposedly, there are a dozen accounts across social media that spread the massive misinformation, they said. So they went after the disinformation dozen. Obviously, this guy is highly involved. So the court says it is ordered that Rob Flaherty cooperate with the deposition. Andrew Slavitt, same story. He's at the White House. The judge orders Andrew cooperate with the request to be deposed. And there are several others, but we'll finish up with a channel favorite here, now that Zulu's in the chat. Jen Psaki, former White House press secretary for President Biden. She's also a named defendant in this case, and the states moved to depose Psaki for a whole multitude of reasons. The most pressing being that as the White House chief spokesman, Psaki made a series of public statements that did the following. 1. attested to her personal knowledge of the participation of high-level White House officials with big tech. And number two, she, every day out there, was reinforcing the public threats of adverse legal consequences to social media platforms if they did not increase the censorship of views disfavored by federal officials. Thus, she both admitted to personal knowledge of pressure to censor from federal officials directly engaged, and she was doing it in a highly impactful and visible fashion. Jen Psaki was out there every day saying, oh, we just wish that these social media companies, we wish that Facebook and Twitter were being more responsible, blah, 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 all day long. We're all sitting here. Jen, we quiet down a little bit, okay? You changed your story already. You said the opposite 2 months ago. But the state's file, they say, the state's complaint details the statements that Psaki made as they relate to these claims. For example, on May 5th, Psaki stated at a White House press conference, she said, quote, "The major platforms have a responsibility related to the health and safety of all Americans to stop amplifying untrustworthy content and disinformation and misinformation, especially related to COVID and vaccinations and elections," Psaki said. Psaki stated at another press conference, July 2021, that the administration is, quote, "in regular touch with social media platforms," and that engagements happened between members of our senior staff and members of the COVID team. So Psaki's like, oh yeah, no, we text each other every day. What's the big deal? And she also stated that there was a disinformation dozen. All 12 of them remain active on Facebook, despite some even being banned on other platforms, including Facebook. Ones that Facebook owns. She said Facebook needs to move more quickly to remove harmful, violative posts. Posts that will be within their policies are often up for days. That's too long. The information spreads too quickly. We have to delete. Jen Psaki's like, give me the keyboard, baby. Delete. She wants them gone. Psaki also called on social media platforms for consistency in banning disfavored speakers, saying you shouldn't be banned from one platform and not others. If you're off of Twitter, you should be thrown off of YouTube and TikTok and Facebook and Instagram. You should be deplatformed entirely. That's what Psaki wants it. They say that the states further allege that along with these statements, Psaki also demanded, quote, robust strategies for social media companies to censor harmful posts. She stated that President Biden himself was concerned about social media platforms and thought that they should be held accountable for the harms that they cause by spreading disinfo. And she also said that the Biden administration remained regular contact with them. The state sent a bunch of interrogatories, list of questions to Karine Jean-Pierre. She's Psaki's successor, but she couldn't answer everything because she lacks the knowledge because Psaki no longer works there. That's why we need Psaki. Now, the court continues, they say. The judge writes, the court finds that the states have proven that Jen Psaki has personal knowledge about censorship issues between the Biden administration and big tech. The court has considered that Psaki was a high-ranking official at the time, especially when she served at the White House. However, this rank does not mitigate the relevance and the need of her deposition as it relates to this case. And any burden on Psaki is outweighed by the need to determine whether free speech has been suppressed. The court has determined that there are substantive reasons for taking the deposition. Extraordinary circumstances are present. As stated above, Psaki has made a number of statements that are relevant to the government's involvement in the censorship issues at hand. And so, accordingly, it is ordered that Jen Psaki cooperate in the state's request to depose her for the discovery injunction. Jen Psaki going to be making her way over to the deposition room. You can see the rest of these people are all ordered deposed. Let's just go through very quickly and see who else is on the list. Elvis Chan, FBI agent. He was apparently communicating with Mark Zuckerberg, and they censored the story of the Hunter Biden laptop. Meta talked about this on the Joe Rogan show. And so you can see the judge ordered Elvis Chan must cooperate, ordered to cooperate with discovery. Jen Easterly from CISA, Cyber Intelligence Security Administration. She's also ordered to cooperate with the request. CISA, misinfo, malinfo, team member Lauren, guess what? Her too. She is ordered to cooperate with the depos. Surgeon General Vivek Murthy, same story with him. He was all over the place, censoring like crazy. Court says he's got personal knowledge. He's also a high-ranking official, but guess what? There are exceptional circumstances here, and he was a big part of this. So the request for a depo is granted. It is ordered that he cooperate with the depo. Others, same approvals, and the list goes on until we get to the conclusion where the judge said for the following reasons, everybody is getting deposed in a beautiful order signed on the 21st day of October by Terry A. Dowdy, U.S. District Court Judge out of the great state of Louisiana. All of those Biden officials sitting for depositions, and my friends, that is a fun victory. Can I just tell you that? Anthony Fauci, Psaki, Vivek Murthy, we've got the whole smorgasbord of little corrupt censors who are all going to have to be sitting down for depots by the incredible Mr. Schmidt out of Missouri. And so, of course, we will continue to cover this. I do hope that you join us. And when Jen Psaki and Fauci, when they sit down for those depositions, well, we'll have to cover those here, and I hope you join us. Thank you for subscribing, and thank you for liking this video wherever it is you are watching it.